tell us about the talc settlement?
Well, there is no talc settlement. There is, at some point, there was a proposal by J&J in bankruptcy.
Johnson & Johnson.
Johnson & Johnson, that there be a talc settlement. It was, in our view and the view of people who really have worked on these cases for many years, inadequate to compensate the people who really were injured with using Johnson's baby powder.
Will you just give us a recap of the case?
Of the case from what happened? I mean, for 50 years or more, Johnson & Johnson was aware that there were serious safety concerns with talc, which after all is mined from the earth and gets brought up with the product. Anything that's in the ground. We found asbestos, we found nickel and chromium and all kinds of things that are carcinogens. And for years, it ignored warnings that there was a serious risk. Went after scientists that were publishing papers. And this went on for half a century.
Wow.
And they had plenty of opportunities to take it off the market. And the really important thing is, this is a cosmetic. This is a product that people don't really need. And there's a safer alternative. Right now, if you go to the supermarket, you're going to get baby powder with cornstarch and not notice the difference.
So what was the value of them to talc for so many years?
Well, what was important and what distinguished Johnson & Johnson from every other pharmaceutical company was its iconic products, whether it be Tylenol, whether it be Johnson's baby powder. And those are the things that they used to create goodwill in the minds of the American people. When I know when I was born, when my kids were born, they received a baby blanket and a bottle of Johnson's baby powder when they left the hospital. So it was really something, that a brand that allowed the company to distinguish itself in the marketplace, and it was built on trust, and they broke that trust.
All right, and so where and are there going to be payouts now? Like what?
So what happened was almost 2 years ago, actually 2 years ago, right about now, Johnson & Johnson, faced with people who were making claims for ovarian cancer and mesothelioma, decided that it was going to do what we've called the Texas two-step. They basically took the company that made the Johnson's baby powder, took the profitable part and made it a separate company, took the part with baby powder and sent it into bankruptcy. And that company was called LTL. This way the public wouldn't really know it was Johnson & Johnson. And they, for 2 years, we have been stuck in bankruptcy while they tried to cram down a settlement against people, hoping that people would just get tired and want to move on. And I just want to take a second to talk about the two-step, if you don't mind.
Yeah, no, that actually is sort of why I wanted to, get to this. So this happens a lot, right? I mean, like Alex Jones is trying to do this. I think, sort of like more famously, maybe,
right.
Or, people are aware of it. But this happens a lot. I feel like it happened also with the C8 DuPont case on some level.
It happened with 3M. Tried to do it with the earplug litigation. They tried to do it there. Other companies are trying to do it. And what really distinguishes...
Is this a new phenomenon?
It is totally a new phenomenon. And what really distinguishes this from other cases is, kind of something basic that gets lost in all this. Johnson & Johnson is not, nor has it ever been, a bankrupt company. And so the tools of bankruptcy are there to allow people, companies, individuals, who start a business, who get into financial trouble. It gives them relief, and it gives people a new start in their lives. I mean, if you think of somebody who owns a family farm, they declare bankruptcy, they're able to wipe their debts away and start again And our system really, that bankruptcy system, it's actually in the Constitution. And what companies like Johnson & Johnson did was take it to a new level. And it's an incredibly powerful tool, because once they file for bankruptcy, all litigation stops. You know, and in a case like this, you know.
So in other words, you don't even need the judge to sign off on a protection of creditors. There's an automatic, I'm in like a safe harbor as soon as I declare, regardless of what the outcome is going to be.
It's called an automatic stay. And then then what they do is they take the bankrupt company and then they expand it to include Johnson & Johnson, who never declared bankruptcy, because if Johnson & Johnson had declared bankruptcy, it would subject its company, its assets, to the oversight by a judge. By doing it this way, they continued to pay out billions of dollars in stock dividends, and then kept these poor women who have ovarian cancer stuck in bankruptcy. It's really
I don't understand.
criminal.
How do you declare bankruptcy but not actually have the proceedings go forward?
What they did was they took this shell company, they put all the liability in all their talc liabilities into that company, and then they said, well, you know, that company can't pay out its debts, and so now it has to be in bankruptcy. And it's,
but how do you put your liability into a different company? I would like to do that.
you know, I'm watching your face as you're asking me this question, and you're scratching your head saying, how is it possible?
Well, yeah, I
you
mean,
do it?
like, is there a way like I can take like my car payments and put them on somebody else
You
and
cannot.
say they don't have any money left?
You cannot, and that's what was really unique about this. And look, I mean, if Johnson & Johnson was bankrupt, I mean, if its liabilities were greater than its income, or if it wanted to subject itself to the oversight of the court, fine, declare bankruptcy and we'll do it. But it didn't.
But how do you like transfer those liabilities? That's what's going on here, right?
Yeah.
I mean, it's not the bankruptcy. LTL or whatever the company is may very well be bankrupt, but what was their one function to do? Just to buy other people's liabilities?
Yes.
I mean, that's not. It seems
They
like
made no products. They had no employees. I mean, they had a few employees basically to administer. LTL stands for Legacy Talc Liability. Okay, that's what the company was for.
But how do you, as someone who like I brought suit against you,
Right?
How do you say like, okay, the part of me that you brought suit against, I've transferred that to another person? Like, how do you do that as an entity, as a corporate entity?
Well, the corporate statutes of different states allow companies to, and we see it all the time. They divide, they merge, they separate, they develop new configurations. And under the Texas statute, they were allowed to divide the profitable part of the company, allow that company to move forward, and then keep and give the bad parts of the company,
the ones that just had liabilities.
And it was only, I mean, it wasn't all creditors, right? It wasn't the people who, you know, built the buildings and swept the floors. It was only women with ovarian cancer and as well people with mesothelioma. They were the only people that were subject to this. And it was, you know, I mean, look, they just held hearings in Congress on this, and on a bipartisan basis, they were outraged. I mean, Congress was outraged. This is not what they envisioned the bankruptcy code to do, to shield profitable companies. It's an incredibly powerful tool that was, in my view and the view of many people, not only was misused in this case, but creates a threat to our system of taking a case, bringing it to a jury of your peers, and allowing them to decide whether or not you should be compensated, and if so, how much. And what it does is, you know, a lot of people say, well, you know, a lot, including the bankruptcy judge, said, well, you know, why don't we make an administrative process and take that right away from people? They can get paid on a grid, and you know, it's more efficient, you know. But our system our system depends upon our ability to go to court,
Right.
and address grievances. So it was clever, but it was wrong.
And so how do you deal with that? I mean, like, what do you do in that situation?
Well, okay, I've kind of left out something that is really important. Both the Third Circuit Court of Appeals dismissed the bankruptcy in April of this year. Johnson & Johnson immediately refiled it.
So Third Circuit, and that's the Texas and the...
No, that's in Philadelphia. They filed. They ultimately, the case was actually transferred to New Jersey, where Johnson & Johnson is.
Oh, I see. Okay,
and so
the Fifth Circuit is in Texas, and but okay. So the Third Circuit said, no, we reject your bankruptcy.
Right.
From talc liability,
LTL.
To fake company, we reject your bankruptcy, and so they're still on the hook. They have no protection from them, and they can't go into bankruptcy. So but they did. That's the thing that's so crazy, Sam, is they, within an hour of the dismissal of the bankruptcy, after the Third Circuit said they're not in financial distress, they don't get to use the bankruptcy code, they refiled bankruptcy a second time, and they tried to argue that a lot of claimants or potential claimants supported them in doing it, and therefore they get a second bite at the apple. In August of this year, following the precedent of the appeals court, the bankruptcy court dismissed it again. So we are now asking us where we are now. We're getting ready for trials. We are looking forward to trying cases, and we're back to where we should have been 2 years ago. Okay, and so you're trying cases, and who's the defendant now? Is it still Johnson & Johnson, or do you bring in
LTL? Good question. LTL is now the company that owns the liability. We're bringing in Johnson & Johnson, and we're bringing in the old company, which is called Kenview, and we're bringing them all into court. And one of the things we expect the jury to know and understand
how they've
tried to avoid responsibility for what they've done to these women over half a decade, half a century.
And so there are cases that have already been won, or
there are cases that have been won, cases that have been lost,
and they're waiting for payout from LTL, or no?
There have been cases that have been paid. There was a very well publicized verdict of several $1 billion out of Missouri. There were multiple verdicts for both mesothelioma and ovarian cancer victims, and there have been losses as well. But that's our system, right? I mean,
right. No, and so let me ask you this: so these cases are individual, or how are they massed?
They're individuals.
They're individuals.
And we're trying to get, we have cases we're trying to get set in the federal courts and the state courts around the country. And it's our desire to show Johnson & Johnson that we're serious, that they've been delaying this process for a long time, and we're not giving up.
So the idea is Johnson & Johnson realizes that there are thousands.
Right now there are 50,000 claims.
Okay, so there are potentially 50,000 trials out there to be had. Some of which maybe they'll win, some of which maybe they'll lose. And ultimately what you guys are looking for, if you're representing, you're obviously not representing all 50,000,
right?
But is an opportunity for them to just say, we're going to give a blanket settlement that on average will cover, or will create an account in which people could apply to in some fashion.
Or in the end of the day, I mean, this is about human beings. This is about people, their families. And if they were to offer money that I felt I could recommend that would fairly compensate them, I would do that. And so if they made, like they do in many mass tort cases, I mean, there are cases that are larger than this in terms of the numbers. And if a company were to make, if the company were to make a, there are plenty of vehicles they have to resolve these cases.
Right.
They just chose the one where they had all the power, and the women and victims did not have the power. And that's the travesty. That's what makes this case different from all the cases that you've heard going forward. You've heard in the past, and a profitable company. I mean, Johnson & Johnson is a $500 billion company that has a rating, a financial rating better than the United States government, right? And the idea of Johnson & Johnson using the bankruptcy code is just wrong.
Right.
We don't do that in this country. I mean, we pride ourselves in the fact that, you know, individual people who are your neighbors can resolve disputes. And they wanted to take that away because they're big and powerful. And we said no.
And so when will you have a sense of, like, I mean, it sounds like the attempts to plead bankruptcy are sort of over with, right? I mean, how many bites at that apple?
You know,
at one point they eat the core and there's nothing left.
They have shown themselves to be shameless. So whether what they do, we will deal with it as it comes. I feel like whether it be our elected representatives or the public are kind of turning on them for what they've done. And I think the public has got it right. And I am pleased that people are outraged by what they've done. And so, you know, is there a possibility they try to do it again? Sure, they could try to do it again. And, you know, we will take that as it comes. But right now, we're planning on going to trial.